I have seen something occurring enough that I think it can probably be called a trend, in that I have noticed there has been a big uptick in the issuance of 221Gs for individuals that are applying for H-1B visas who work with consulting companies, in the circumstance that the individual is working subject to a petition where they are working in-house. So what I've seen is essentially, if they are looking at your H-1B petition and they say, this person looks like they're working in-house, they will issue a 221G, interview the individual extensively about the specifics of the project, and then send the petition back to USCIS for FDNS review. And I have seen that enough times that I don't think this is something that's just kind of a one-off. It seems there has to be some sort of policy internally that was made by the State Department to take this cause up, because I've seen it happen to someone who had no documents to prove their project was valid. I've seen it with someone who had documents to prove their project was valid. They treated both cases the same. They seem to operate under the guise that if you have an in-house project and you work for a contractor, a third-party contracting company, or a company that does any level of third-party placement, there is a default within the State Department that your case has a fraud issue associated with it. And so I would say, if you are someone that works in that circumstance in the United States presently, and you are going for a visa, you need to be prepared, because you're likely going to be subject to a very high level of scrutiny and a potential issue with FDNS that could conclude with FDNS attempting to revoke the H-1B petition.